selection stage of public procurement focuses on who the potential contractor is, and the assessment of the capacity and ability of potential contractor to perform and meet the requirements of public contract. In other words, the selection stage ensures that the bidders are reliable and responsible, that they have sufficient experience with the type of contract that is being procured, and that they can deliver it properly. 4 types of qualification criteria are used at the selection stage under EU procurement law: exclusion grounds, suitability to pursue professional activity, technical and financial capacity. 2 of them may include sustainable consideration, the exclusion ground and the technical capacity. This is what we will focus on. Article 57 of the directive regulates exclusion grounds. The article includes a catalogue of 2 types of exclusion grounds: mandatory and discretionary ones. The bidder might be excluded for sustainable violations in both of these categories. In regards to the mandatory grounds, it is particularly relevant to point out exclusion based on final judgment for child labor and other forms of trafficking in human beings, and breach of legal obligations to pay tax or social security obligations. The catalogue of discretionary grounds where a public buyer may, but does not have to, exclude companies for sustainable violation is broader, and it includes unpaid taxes or social security obligations, non-compliance with sustainable principle from Article 18.2. An example here could be a waste collection company that has disposed of waste illegally. In such a scenario, the company could be excluded from the tender for waste collection services. Other discretionary grounds include grave professional misconduct, which renders the integrity of the bidder questionable, significant persistent deficiencies in the performance or substantive requirements under the pure contract, which led to termination of comparable sanctions, and misrepresentation. Some of the discretionary grounds are potentially comparable and overlap with each other. For example, particular behavior, let's say polluting water, during the manufacturing of goods could lead to exclusion on the grounds of violation of Article 18.2 or grave professional misconduct. Before I go on, let's clarify the concept of professional misconduct according to Fort Poster case. The concept covers all wrongful conduct which has an impact on professional credibility of operator at issue, and not only violation of ethical standards in the strict sense of the profession to which the operator belongs. So the 2 mentioned exclusion grounds relate to bidder's integrity. If that is questionable, the bidder cannot be deemed reliable, as confirmed by the court in the case of Mecca or Tim. In such situation, the bidder becomes unsuitable to receive the award of a public contract, irrespectively of the technical or economical capacity that they have. If the used in the mentioned before example of pollution of water occur already in a previous performed contract, applicable also could be the significant persistent deficiency in performance of substantive requirements under pure contract exclusion. In both Mecca and Delta cases, the court stated that this exclusion ground is particularly intended to enable public buyer to assess the integrity and reliability of each of the tenderers, and that it is based on an essential element of the relationship between successful tenderer and the contracting authority, namely the reliability of the successful tenderer on which the contracting authority's trust is founded. Note on timelines when it comes to exclusion grounds. The discretionary exclusion criteria are subject to a maximum exclusion period of 3 years from the date of the relevant event, unless a shorter period is prescribed by national law or a longer period is prescribed by a judgment against the company. At the same time, 5-year period applies for mandatory exclusion. It is important to keep in mind that the role of exclusion ground is not about punishment of the bidders, but rather it is to protect the integrity of the process. Therefore, the bidder can self-clean. That is to demonstrate their reliability despite the existence of one of the grounds for exclusion. Now, moving on from exclusion grounds to professional and technical capacity criteria, Article 58.4, which focuses on the ability of the tenderers to perform the contract. They usually describe qualifications, knowledge, and abilities, such as availability of equipment, resources, and technology, or a description of technical facilities, etc., but also skills and experience of the supplier. Here could be availability of relevant qualified staff with the necessary knowledge and experience, but also the relevant documented projects previously implemented in the performance of similar contracts. Some of the most relevant selection criteria from sustainability perspective may include supply chain management or tracking systems, conformity assessment certificates, and environmental management systems and schemes. So what is or what are the environmental management systems? They are regulated in the Procurement Directive under Article 62. They are organization-related tools aimed at improving the overall environmental performance of the committing organization. They are used in many public and private sector organizations. The best-known systems in Europe are the ISO 14001 and the Eco Management and Audit Scheme EMAS. This system require that documented processes and instruction exist concerning accredited organization or sites and provide for regular inspections and audits. The directive allows the public buyer to require an evidence of environmental management system that the company has in place for any contract. Of course, the equivalent certificates must be accepted. Though the ability of bidders to rely on non-certificate system has been reduced, very similarly as it has been done in regards to labels regulated under Article 43. The non-certified system may still be used where bidders can demonstrate that they had no access or no possibility of attaining certification within the relevant timeline for reasons that are not attributed to them, and that the measures that they propose are equivalent to those applicable under the requested environmental management system or standard. While the equivalency is to be accepted, in the Evropaiki Dynamiki case, the General Court stated that the public buyer was allowed to award different marks based on the quality of the evidence produced regarding environmental management measures. The quality here has been related to the presence of third-party verification, which was allowed for the awarding more points when assessing the quality of companies' EMS. The qualification criteria established by public buyer and the list of documents confirming the information of bidders or participants about their compliance with such criteria must be stated in tender documentations or other qualification documents, therefore ensuring the transparency of the requirements. Also, the chosen selection criteria should be related and proportionate to the subject matter of the contract. So, what could be a practical example of what I was discussing? Let's imagine a tender for construction works. We want to build a bridge in a protected area. Such a tender, in regards to selection criteria, would require establishment of a series of specific management measures and ensuring effective protection or in other words, minimizing disruption of natural habitats in the area whilst building the bridge. This could include control of noise levels, use of natural resources such as water and energy, training of employees, usage of clean vehicles for transport, waste collection, etc. In this case, the position of an EMS for construction sites, but not for other sites such as factory, can be used as means of proof that the bidder has the technical capacity to perform the contract accordingly.